G'day, Year 11 students. Just want to talk through the slides from negligence fairly quickly, if we can. So, just to give you a basic background of what we're talking through. Only a short chapter, so hopefully we are doing a nice job of getting on top of things. The first, we looked at a case around Jared McCracken, which I've just flicked through, and these are the notes that you will have access to as well. So we're thinking about the main elements of negligence, the three elements of negligence. Is a duty of care owed? Is there a breach? Are there foreseeable damages? The neighbour principle, coming from the Donoghue v Stevenson case, and defences to negligence, which will include voluntary assumption of risk and illegal activity and contributory negligence. Let's sneak through. Very quickly, it's civil law. And it's about not taking reasonable care and there's some injury or damage. And the person bringing the negligence action, the plaintiff, the person making the complaint, has to prove the case. So we've mentioned already the three elements of negligence, that there has to be an existence of a duty of care, a breach, and reasonably foreseeable damages. I will emphasise on your textbook that this is a really good figure 8.1. on the current textbook, the one that you've got a hard copy of. Now, one of the little quirky rules around negligence is this idea of the eggshell skull rule. So it describes an imaginary person with an extremely thin skull that you're not aware of. But if you hit them in the head and cause more damage than you would expect, you're still responsible for that. It's a way of saying that even if you don't foresee that someone might have a reason for having more damages, you're still responsible for that. So now let's have a look at our elements of the duty of care. Okay, is there an existence of a duty of care? So the first element to think about is it's foreseeable. Is it reasonable to anticipate the potential result of an action? So for example, if you drive while you're drunk, yeah, it's foreseeable that you might get in an accident and do something to someone else. I've got the example there of mowing next to a car and a stone coming up from the motor mower. Is it fair and just to impose a duty of care on the defendant? This might come down to, for example, thinking about an injury that comes in a sporting sense, right? There's a lot of people playing social sport every weekend, so there might be a reluctance to impose too much of a burden on them for an injury that occurs in that situation. And proximity. Is there a closeness? Is there a physical proximity, for example, being in the same classroom together? Is there a circumstantial proximity to people doing things together? Maybe a professional advisor, you go and see the doctor, so there's a circumstantial proximity there. Or is there a relationship between the act and an outcome? For example, you're mowing the lawn and a rock comes out, shoots out, and damages the car parked on the front of the road. We also looked at this case, Strong v Woolworths. And the idea of this one was whether Woolworths had taken enough care in cleaning the environment around it, and they were found that they hadn't. They should have had a more thorough system for cleaning, and so they had a duty of care to a customer. They hadn't met that duty of care. There were damages, and so it is a useful precedent case for yourselves as well. So now we can move on to the Donoghue v Stevenson. This is the slug in the bottle case. Someone goes to a cafe, has a bottle of ginger beer. A long time ago, 1932 is the case. The question is there someone responsible for that? It's not a true contract. There's not a direct contract between the person who made and bottled the ginger beer and the person at the cafe. But this is where the idea that the neighbour principle, that if you can see that your act will influence someone else, you've got a responsibility. And that's why this is important. It goes beyond just saying there's a duty of care when there's contracts. It says there's a duty of care when our actions can influence someone else. Okay. So that's that question. That the case is important there because it's in the context of, is there a duty of care owed? And that's what Donoghue Stevenson talks about and sets a standard for. And causation is there a link between the damage and the behaviour? How close is that? Is there a significant closeness, or is there something that happens a couple of steps removed? I don't think that's something that the causation there is going to be something you have to deal with as much. So we've looked at this duty of care, and the two key elements are proximity and foreseeability. They're the two I'd focus on. I would get less worried about causation. So now we move on to the breach of that duty of care. And this is important. I emphasised this in an email to yourselves earlier this week, but has the defendant failed to reach the standard of care? And the standard of care is the degree of caution required by a reasonable person. That reasonable person isn't someone that's set in stone. It's this anticipation of what a reasonable person would do. So if the court found that a reasonable person would not have acted as the defendant did, then it's likely that a breach of the duty of care happened. Right, so if there's an example, go back to that mowing of the lawn. I take it you're a little bit familiar with mowers with the blades underneath. You know, if you've got a front strip at the front of your road that's mainly gravel with just a little bit of road, with a little bit of lawn, you know there's going to be a bunch of stones that are going to be kicked up there. And if you mow that lawn while there's cars parked there, you know that there's going to be damages done. So yeah, you might say in that case that a reasonable person wouldn't mow that part of their lawn, the gravelly, with rocks, while there are cars parked there. This was interesting. Wyong versus Shett. This was a case about water skiing and a shallow area in the lake, and whether the city council, Wyong City Council, should have clearly marked that there was a shallow area. Right? So would a reasonable person in a position of the defendant have foreseen a risk of injury, and what would a reasonable person have done in response to that foreseeable risk? And in this case, they found that it wasn't reasonable to expect a city council to be aware of all the shallow parts in the lake and have them all signposted out for someone, as much as there was a tragic injury that came out of the situation. So now we're on to this damages. Damages are caused, these foreseeable damages. You now get to the point of saying a duty of care has been owed, there has been a breach, what are the damages? So the breach has to lead to damages for the plaintiff to be able to take action. And we looked at the football player story where he was injured in a tackle but went on to have such a successful career as a property developer, he earned more money than he would have by playing football. So there wasn't actually damage in that situation. That was Jared McCracken's case. And most cases proving damages are pretty simple. For example, we looked at the flicking of pieces of paper around a classroom that hit someone in the eye and did damage to the person's eyesight. That's pretty obvious that there is a link there. Sometimes there can be an intervening act and that breaks the chain. So if you come across something and say, well, it doesn't look like it's quite as closely linked as it should have been, then that's something you can refer to as well. So if there is an intervening act that breaks just this really close relationship between an event and an injury, that's worth commenting on. That might change the legal situation so that the plaintiff is not entitled to damages. Causation is, has the harm or damage been caused by the actions of the defendant? Is there a direct link between those two things? Now remember, with direct link, we also look at this idea a little bit later on of vicarious liability, so that an employer might also be responsible for the behaviour of their employees. The but-for test, if the defendant had not taken those actions, or put it the other way, if the defendant did take the actions, either way around, would the harm or damage have occurred? So one of the interesting cases we talked about with the but-for test was the drunk driver who ran into a car that was parked in the middle of the road. And so you say, well, it was a van parked in the middle of the road, but for the van parked in the middle of the road, the damages wouldn't have occurred. In that case, you had to say, well, there are other things that have contributed to the situation. Okay, so the damage can't be too remote. If you fall off a stage in an event, and 8 months later, 10 months later, you start to complain of back pain and link it back to there, that's going to be problematic. There's got to be a close link. That but-for test. Okay. Negligence is one of the reasons we're looking at negligence, because it's a very common type of claim, and we put in place negligence there to compensate victims and to deter members from being involved in unsafe behaviour. I think I told a story about boat ramps. People would slip at boat ramps, and there were some negligence cases, and now councils pay a lot more attention to keeping them nice and clean. Precedent's really important because if you find a precedent case, you can discuss a precedent case. That's what influences the ruling of judges in similar or lower courts. If the facts are similar, then the judge, the magistrate in the lower court has to follow the ruling of the higher court. So precedent becomes a really important thing. This goes in a little bit more detail of Lord Atkin's duty of care. And this last point is most important. A neighbour is the persons who are so closely and directly affected that I should have reasonably had them in my thoughts, contemplations, as being affected. People you can see you should be able to see are affected by your actions. So then we come to defences of negligence: contributory negligence, voluntary assumption of risk, and the illegality of an activity. We're going back to the eggshell rule, saying that you have to take your victims as you find them. Right? So if someone is more prone to damage in a situation, you didn't realise that, you're still responsible for harm caused. So contributory negligence is where the plaintiff, so the person bringing the complaint, the person who's been injured, has acted in a way that they've contributed to their damages. And often one that is quoted is, if a person's aware that they're getting into a car with a driver who's affected by alcohol, they've contributed to any damages that happen after that. And you talk about a percentage. And look, in the exam, if you get a contributory negligence situation, the case say, don't get too carried away with being precise with the damages. Just say why they've contributed an even share, a smaller share and make it 20%, an even share 50%, or a significant share and make it 70%, and you reduce the damages by that amount, which is an exciting way of getting some maths into legal studies. The second defence, and I should say contributory negligence is a partial defence because the defendant might still have to pay you money. So they say, well, the plaintiff is partly responsibility, but there's still some payment of money. Voluntary assumption of risk. So if you're involved in a risky and obviously risky activity and you're injured, the classic one, you're playing football and you get injured through just through some of the collisions on the field, then voluntary assumption of risk is a complete defence. And it's a little bit why, while they don't have a great deal of legal power, when you're involved in a risky activity and you sign a sort of a disclaimer about it, it is a way of pointing out to you that you're involved in a risky activity. So it may have some power in arguing this area. And the last thing is the illegality of activity. If you're involved in illegal activity, if you're robbing a bank with a friend, when there's an injury and you get away, there's no duty of care in a situation where there's an illegal activity going on. Vicarious liability is an important thing. I think it's just about the last thing we'll look at, and it's this idea that if an employer is working for you, if an employee is working for an employer, it's still the employer who can be responsible, or if there's a contractor. Right, so a teacher is an employee of a school. The school's liable for damages if the employee behaves in a reasonable way. So rather than, if there was an accident and one of you got hurt in legal studies, you may, and I was just doing my job in a normal way, you'd more likely probably just sue the school than you are to sue myself, because the school's responsible, even though I might have been there supervising, providing my supervision was reasonable. And most common when an employer is responsible for negligence of an employee. And the idea is that vicarious liability is that employers should have a responsibility to train and supervise their staff members. So if you see a situation where the training or supervision hasn't been as good as it should be, you're really saying, well, probably some of that fault rests with the employers, and that might be part of the action. So they're the key notes that I wanted to go through with you today and for you to have access to. Go back to the email on damages. I haven't talked about that, but remember the 3 types of damages: the general damages, pain and suffering, on the 100-point scale up to a maximum, use either 250 or 330,000 as the current term. Then the special damages, which are the specific costs that you can find, plus the economic loss up to 3 times the average salary over a period of time. And I think we've covered the basics fairly nicely.